But you also, the psychological force is sufficient. Psychological, forcible compulsion is not only physical, it's psychological. So you might say, well, can you find, you might be able to find, and force can be a threat of force. It doesn't have to be the actual application, it can be the threat of force. So you have enough here for the Berkowitz test to be satisfied. Okay, why is Berkowitz satisfied on these facts?
And these psychologically forced that when you took her keys and her phone and told her that she can either sit here or stay in the car and she's in an unknown area. And he physically forced her and he grabbed her neck and he made her take the car.
So you may have physical force inconsistent with consent under the circumstances with the neck. You also could say she knows that she's not going to be able to leave until she complies. It's not really, it's inconsistent with, maybe the psychological manipulation is inconsistent with consent. So that's how you look at that. Apply the statute of courts analysis and MTS to these facts. How about that? So what kind of force was MTS?
Intrinsic.
Intrinsic. So so you gave us the definition of this
It's the amount of force required to achieve penetration.
only that degree of force required to achieve penetration, and what must you show from the victim for it not to be a rape under the intrinsic test? What do you need to show?
The amount of, the minimal force.
Right, minimal force, but where's the focus now? The other focus was on the male. Where's the focus here?
Like, she didn't try to, like, pull away from him. Like, she didn't use any force. Like, she just complied to him and, like, she just shared intimacy.
Did she just
with him.
comply, or?
She cried.
She was unresponsive. She was unresponsive.
She verbally resisted, certainly. Is that enough for the intrinsic test?
Like, she didn't stop him from doing it. She, like, while, after saying no, she allowed it to happen. She was unresponsive, but that's not being, like, responsive, but was using force to try to stop it.
The MTS, they said that was rape, did she use this? What must you show from the female under the intrinsic test for there to be rape?
She gave consent, whether she gave consent or not. Like if she said
Right.
no, then that's
Affirmative consent. You don't, it's not enough that you're indifferent. You need to show affirmative, voluntary and affirmative consent. You don't have it. She said no. She said no. You don't have voluntary and affirmative consent, but you have rape. Okay, third one, assume that what you read actually was a scene, or read was a scene from a movie. Assume what you read actually was a scene from a movie. From Y's audition for a movie. The director D tells Y that she can have the role if she shares intimacies with him. So what you just read is scene from a movie. Now D says to Y, you can have the role if you share intimacies with me. D actually already has given the part to another actress. Y later learned that she did not get the part, despite having spent the evening in bed with D and claimed that she was raped. Did D rape Y? So D says to Y, okay, nice audition, you can have the part, you sleep with him. She sleeps with him and she doesn't get the part, and she says, I've been raped. Is that rape?
No.
Okay, why isn't that rape?
Fraudulent.
Right, fraudulent inducement, you consent to the act, but unfortunately, for a reason that was fraudulent, but you consent to the act and that's the truth. Okay, now we have, it's actually D, not E, but consider the rape shield statute. May the defense, this is a little bit more difficult. May the defense attorney introduce evidence that while he was flirting with X throughout the evening, just in, so this, now we're going back to the main, may the defense attorney introduce evidence that while he was flirting with X throughout the evening, dressed in a provocative manner, and had dated 5 men whom she met on the dating site, and had slept with one of the men whom she met. So what does the rape shield statute say?
The prosecution may not introduce evidence relating to the victim's sexual relations with individuals other than the accused, and may not introduce evidence pertaining to the victim's reputation for chastity.
Right. So in theory, cannot introduce evidence, sexual activity of someone other than the accused. But he said that because the Sixth Amendment Confrontation Clause guarantees an individual the opportunity to confront their accusers, that there are exceptions to rape statutes. Kobe Bryant could introduce, in theory, evidence that the victim had sexual activity with somebody the day after she had interaction with him, because to show that the argument was that she was bruised, that was inconsistent with the consensual relationship with Kobe Bryant. He was able to introduce that sexual relationship with her boyfriend the next day, because even though that violated the rape shield statute, in theory, it would deprive him of a relevant defense source of injury if he could not have introduced that at trial, and that's why they brought the charges. So, do any of these facts have independent significance such that you should be able to do this? Should be able to make reference to this?
I believe the only time that they could bring up is that she slept with one of the men that she met on the dating site, but other than that, I wouldn't say.
So that would be relevant because it's a similar situation. You meet a guy on a dating site, you slept with one of them, you must have slept with me. It's called a pattern of activity.
I didn't consider that, but I was gonna say her interaction with X would be able to be brought in, because what she did could have led to during that, night, and I was gonna say everything else should be, I mean, it's similar situation, but it should be not admissible because it's past.
Yeah, what you're bringing up would go to the issue of consent. But of course, judges have to decide this. Okay, she looked like she was interested, she must have consented.
Well, in the cases of the other, people, like, just because she had sex with one of the guys doesn't mean that, like, it was a similar
Well,
situation.
that's the other argument. In making this determination, the court says, okay, what are the benefit? A, you should be able to do this. B, if you can show that it has some significance to your defense at trial, perhaps you should be able to do it. But bottom line, is it too prejudicial? Meaning, would it prejudice the jury against the defendant, which it very well might, and you could make the argument, obviously, always, that those other situations aren't this situation, and you shouldn't be able to bring it in. So it gets complicated. Got all these considerations running around. Okay, at trial, Y claims that during her sexual interaction with X, that she told X that she had to go home and wanted X to end it, and that she did not enjoy this at all. X disputes that this statement was made. X claimed that the music in the apartment was so loud that no one could hear anything. Was Y raped by X after X continued to interact with her after Y asked X to stop? So how about that? What's the issue there?
Withdrawal of consent.
Okay, what do you need for withdrawal of consent? Definitely